Hello, this is Antonio Gangale. Earlier, in my YouTube videos, I discussed two earlier cases. And this particular case, of the third case, is probably the most egregious. This is the one I really want to get into and explain how they affect the two other cases. In this particular case, I was petitioning pursuant to the First Amendment to the U.S. Constitution, which the First Amendment, Congress shall make no law respecting an establishment of religion, or prohibit the free exercise thereof, or abridge the freedoms of speech, or of the press, or the right to the people peacefully to assemble and to petition the government for redress of grievances. Again, I had petitioned the Northern District Court. I was, as you see, pursuant to the U.S. First Amendment, and I was adjourned from filing any new lawsuits or other documents with the court.
Wow.
So you understand, any other documents, that means I couldn't file a notice of appeal because you file it with the court.
Right.
There's serious legal issues regarding this.
This doesn't even seem like it's possible to
Well,
bar
so I got sanctioned
like
for exercising them. And moreover, so in the cases, the judge never gave notice or an opportunity heard before this order was entered. So there was apparently no due process. Never warned or cautioned. Never explained what particular matters meant in the case, or give opportunity to present evidence in cases, or the ability to amend complaints. So like a pro se litigant is supposed to be less stringent standards and be able, if something, they're supposed to explain what things mean, give you an opportunity to amend. So none of these procedures appear to have occurred in the earlier cases or whatever. So it's very disturbing what this court had done.
Yeah, so it's like a punishment.
There's an Eighth Amendment right of cruel and unusual punishment. So these affect all other cases in your ability to protect yourself and other. If you have no rights,
yeah, but you didn't do anything.
Right. So it appeared to be cruel and unusual punishment. So there's a case in Trop versus Dallas of a cruel and unusual punishment.
Did he cite certain cases, or didn't even do that?
I think he cited Trop. In Trop, I think it had 176 cases the guy had, in excess of 300. And then there were others that he alleged that he assisted in. So in no way is mine close to Trop. And
No,
he was given notices and warned.
Two.
I believe there were three.
Okay.
But here, and let's examine those cases. So you're supposed to enumerate and discuss all the factors when you issue.
This barring?
And Rule 65, if you're going to issue an injunction or TRO, temporary restraint, is that you have to give notice to the adverse party, so that wasn't done. So due process and what is clearly an issue. This case gets much more deeper, because there would have been an issue that if he enumerated or discussed all relevant factors, there's a clear issue that he would have had to cite the United States versus Union Cheese Company case. And let's just quickly state, as you'll see, that I'm an interested party in the action. So you want to examine if that order from that very court is possible. So a court permanently barring you, and then find out that the court engaged in unconstitutional activity before and engaged in cruel and unusual punishment against the person.
In another judgment.
Right. Is
the United
you just
States
want
versus Union
right. So you just want to ignore misconduct earlier.
And keep you quiet.
Exactly. It silences you in those cases.
Keep you from defending.
So right, exactly. It is an egregious miscarriage of justice that they did this. Not only sanctioning me in that case, is you're affecting all other cases of the past, present, and future. You'll want to examine in Union case if it's possible, and that'd be an Eighth Amendment violation. So I don't want to get too far into it. You want to examine the YouTube of the issues in the case, and then you kind of understand the magnitude of this order and what the totality of. Not only is the order not possible, it appears.
The Union Cheese order.
Right. And then the injunction here only on notice the adverse party. We don't want to get too far into union because it will take hours. But these declarations that were put before the court, I guarantee to you, they are not true and correct. I guarantee it.
Okay, so let's move on to your...
And the affidavits must be made on personal knowledge, just to determine if they had personal knowledge of the facts. Because they may not even stand of adequate to be put before a court, more or less the factual basis of these. In that Northern District Court, in union issues, if the court had jurisdiction of the subject matter and over the parties.
Okay.
You
were simply just trying to bring all these...
So I'm being sanctioned for that.
All these facts up.
When you're doing other cases, it's like, remember, in union was basically an execution. It really was. If people knew all of the facts, it would, and knew that it was intentionally skewed, and all of that, it would be like this court. And when you look at the YouTube, there is clear evidence that the court had knowledge of certain facts. And to disregard them is so egregious.
And they disregard.
When you're sanctioning a United States citizen from using the courts and punishing him, knowing that you engaged in this behavior, the egregiousness of union, now you've not only that is, it appears that you've exceeded in Trop versus Dulles. This is more primitive. I'm in worse position than Trop. In the United States government has called that more primitive than torture. Congress shall not make no law or abridge it, and I'm being sanctioned for exercising it. That's what I do know. So let's get into, so there's a First Amendment right to petition. Then there's a Fifth Amendment right of due process. No person shall be deprived of life, liberty, or property without due process of law. So there's multiple issues of that. Seventh Amendment right to sue. So there's civil rights issues and whatnot.
Violation.
Eighth Amendment.
Violation against you.
Shall not require excessive fees imposed, or cruel and unusual punishment shall not be inflicted. We also have the issues of habeas corpus. So whenever you were unlawfully restrained or unconstitutionally held,
he triggered all of these.
There appears to be an issue of a habeas corpus, right? Cannot suspend habeas corpus. There's a 14th Amendment of civil rights in state matters. There's ethical duties to report. There's issues with that. Again, as I mentioned, 42 U.S. Code, 1983 Civil Rights Actions. There's conspiracy to deprive rights. That's 1985 actions. There's issues possibly a failure to prevent, 1986 actions. There's potential issues of criminal conduct. So the ability to file verified complaints. Then there's Qualtam cases that it affects. As I mentioned, there was never in these matters did they give me the opportunity did they inform me of what particular things meant in the case, which I believe pro se are entitled to.
Yes.
The ability to amend the complaints.
Okay.
Opportunity to be heard before or to present evidence.
You couldn't even...
And I remember, and then I'm sanctioned for even attempting to file, so I can't file notice of appeal. So there's very...
You couldn't be heard.
Yeah, it's a silencing.
That was it.
So here, case law, the existence of a constitutional right for any individual is dependent upon the mechanism to uphold those rights, protect them from violation or denial. Consequently, access to the court is a pivotal right upon which the vindication of persons' other constitutional protections depends. As this court has continuously emphasized, habeas corpus and civil rights actions are fundamental importance to our constitutional system because they directly protect our most valued rights. Here, meaningful access to the court is touchstone. So if I can't access to the courts,
You got stripped of all that.
the fundamental importance is they directly protect our most valued rights. So how do I protect the rights if I can't access the courts? Here, now for the first time in the 182 years since the founding of the Republic, courts are asked to hold that the First Amendment does not mean what it says. In other words, we are asked to hold that despite the First Amendment's apathetic command that the executive branch, Congress, and judiciary can make no laws adjourning, instead it makes the bold and dangerous far-reaching contention that the court should take it upon themselves to make laws abridging freedom. So the court took it upon themselves to alter the First Amendment and abridge that. Unheard of. Egregious. Here, that every moment continuous rate amounts to a flagrant, indefensible, and continuing violation of the First Amendment. That's New York Times versus the United States.
Wow.
So there is a
So how long has this
determined.
been going
Is it determined that it is a continuing violation of the First Amendment? Now here's where it gets even more interesting. It is established that denial of First Amendment, even for minimal periods of time, unquestionably constitutes irreparable injury. So if there's an irreparable injury, I should be able to immediately go into a court and seek relief.
If you could get into a court,
So now let's
how do you get
raise
into a court?
a stronger. Can I go verbally? Does the First Amendment restrict you not only filing with the court? Can I file it with the executive and Congress? And moreover, does it have to be in writing or can it be verbally? And can they make a law restricting you to do that? And if Congress can make no law, so a petition would appear to be, it can be verbal. Can I do a public notice? And can this count as a petition? And then is it irreparable injury? So are they bound to immediately address these issues? So can we expand?
You would think yes to all those.
If it is yes, then let it be a formal petition and have the public be put on notice and the government formally put on notice.
So are you going to formally petition?
Yes, I formally. But let's go further. The U.S. Supreme Court, Nebraska Press Association, a prior restraint by contrast and by definition has an immediate, irreversible sanction. If it can be said that the threat of civil or criminal action after publication chills, prior restraint freezes. So there's issues of, if you're threatened with contempt after public, so I'm restrained from that. So there's issues that prior restraints are freezing federally protected rights. Here's Cromer vs. Kraft Foods. A judge may restrict a right to his fundamental access to court only in limited circumstances and strict the courts with established protection. That was not done here. And it was not done in my case either. Further, it is unclear if the magistrate provided Cromer notice of possibility of pre-filing sufficient to ensure that Cromer had an opportunity to oppose the court's order before it was instituted.
No
Didn't have that.
There. Yeah.
Further is determined whether a pre-filing injunction is warranted. A court must weigh all relevant circumstances.
Didn't happen.
Like, do you know how?
Didn't happen.
Okay. The magistrate did not enumerate or discuss those factors.
Didn't happen.
Judge must ensure the injunction is narrowly tailored to fit the specific circumstances at issue.
Nope, he did a whole blanket against you completely.
Here, absent that narrow, pre-filing injunctions of other injunctions will not survive appellate review. And what's nice is, block access to the appeal. So it's so egregious. Let's go further. B, E, and K construction. We have recognized the right to petition as one of the most precious liberties safeguarded in the Bill of Rights, Justice wrote. We have explained the right is implied by the very idea of a government Republican form. And it goes on to authorize and adjourn the First Amendment without advance approval of a official imposes an unconstitutional restraint, since the person would have to clear future First Amendment rights in advance with a judge. Again, that's New York Times versus United States. A more serious evil would result if officials could determine what matters could be presented. The opportunity of malfeasance and corruption have multiplied. Crimes have grown to the most serious proportion. The danger of its protection by unlawful officials and the impairment of fundamental securities of life and property by criminal allegiances, official neglect, emphasizes the primary need of vigilance Again, that's New York Times. So in my matters, was there government misconduct in the cases that I had brought before and earlier?
Yes.
So are there issues that they're concealing that through inability? Yeah, in New York Times, United States. No one can read the history of the option of First Amendment without being convinced beyond any doubt that it was intended to outlaw this nation of all time. The First Amendment is well known and is certainly respected. The justices say that no law means no law, and that should be obvious. This appears to be so egregious, a blocking. So not only we see First Amendment rights, how does it affect habeas corpus? And does the petition, now remember in here it says it changed the original Constitution into a new charter in which branches that could not abridge people's freedom of press, speech, religion, and to petition. I can imagine no greater provision in history, Madison and the others framers of the First Amendment. They earnestly believe that it could never be misunderstood. So how does the First Amendment, which again amended the original, affect habeas corpus? So habeas corpus was in the original Constitution. So when someone changes that, when a judge altered and abridged the First Amendment, is he affecting habeas corpus too?
Probably
And how
yes.
is it affecting
Right.
civil rights actions?
Right.
Well, if Congress can make no law bridging, if the judiciary couldn't make it, and legislature, and it's clear and it's supposed to be obvious to everyone that it shouldn't be, what the hell is the judge doing? He's rewriting the Constitution, blatantly. And are you telling me a federal judge doesn't know what the First Amendment reads? He doesn't know First Amendment law? I believe it was willful and intentional and malicious. And again, this is the same court that handled Union. And if it's impossible and they engaged in that kind of conduct,
If Union's
it's clear.
order was
And
impossible,
and people knew that was intentional.
then it's not a far-fetched idea that
Well,
the
so
judge that
this
barred
appears to be
barred
so
you-
egregious.
barred you from accessing
But let's go here.
that
It is established beyond reach of reasonable dispute that federal courts not only may grant evidentiary hearings to ABBA, but must do so at appropriate show. There is no higher duty of a court under our constitutional system than the careful processing and adjudication of petitions for writs of habeas corpus. For it is in such proceedings that a person in custody charged with that error, neglect, or evil purpose has resulted in his unlawful confinement, and he is deprived of his freedom contrary to law. So when I petitioned Gangale versus the state of Ohio, was there careful processing of that? Was there conduct in there that was egregious? And was it error or neglect or evil purpose? Were they withholding evidence? Was everything tampered with? Was there conflicts of interest?
Oh, in your bike case.
Right.
Oh.
So remember,
right.
yeah. So I got sanctioned for attempting to seek relief,
Where you
or
were
in those
wronged.
cases. So
And you were, you know what? Let's make a point. You were wronged by government officials.
all of it.
All
So the
of
tampering is a government employee. The court, like, they're all one thing in common. They're all getting paid by the government.
Yeah. Boom.
And in the Union case, that people, I don't want to keep bringing up Union all the time because you can watch the YouTube. How in the hell do you do a zero tolerance for listeria and other pathogens?
It's impossible. We already
So,
know.
but, okay, if it's impossible, that means multiple federal investigators, inspectors, would have had to be oblivious. We're talking the Cincinnati district who filed or put the declaration before the court. He would have been. You have the expert witness. Then you have all of the U.S. attorneys, the Justice Department, which It would be the Northern District Court's offices, and I believe they forward it to Washington. They're notified, or in part of the case. Okay. So they would have knowledge. Mm-hmm. Then you have multiple judges. While the FDA reports that there's a 12% of listeria coming in.
Yeah, at the same time.
monthly bacteria.
It's probably, yeah.
Like you can't. Do you know how many people would have had to have known? It's just too inconceivable. Okay. The right to access the court and equal protection laws because there was no indication of any assistance at the initial stage of the preparation for the writs and petitions. So are there issues that legal right to have assistance of counsel in the preparations of them? Here, pro se pleadings are to be liberally construed. Here, court emphasized taking in the account of office of the writ and the fact that the petitioner is usually handicapped in developing evidence needed and to support in necessary detail the facts alleged in the petition. Okay. Habeas corpus proceedings must not be allowed to flounder in procedural morass. So when you block someone's access, are you creating more procedural morass or impeding someone's...
Sure.
So it's in direct conflict of Price versus Johnson. And I believe I have a slide of another one of Price versus Johnson. I believe he was unsuccessful in 3 petitions, and on his fourth petition, there he alleged something of fabricated evidence, which in my case was their fabricated evidence. So here, this appears to be in direct conflict
so you're saying
of what federal...
In this case, this Johnson case, that guy got barred, but he was...
No. Oh. Johnson did not get barred.
Or what?
He filed 3 habeas corpus petitions.
Okay.
On his fourth one, he put something in there that the other 3 didn't have. And they granted him relief.
So he had all those chances.
So he had 4 goddamn things. Here, how many times was I before the court? And I'm permanently fucking barred. And here, he's been given 4 chances in one goddamn case. I had multiple goddamn things going on. And the goddamn state is continuously withholding evidence. And I'm not getting legal assistance. And then...
So all these cases that you're bringing up...
Hold on. Let me add one more, because this one, in County of Riverside, person arrest warrant is entitled prompt determination whether probable cause for arrest. Just ask did the New Philadelphia Municipal Court, did they follow rules of criminal procedure, and was that followed? Now, let's also add, in the County of Riverside versus McClellan...
Are you referring to your bike case now?
Yes. But in this case, they allowed him to amend it, I believe. He was on his 3rd amended complaint. Mm-hmm. So in any of my times, did he allow me to amend it? Or to present evidence to the court? So I get completely blown the hell out, and this is incomplete. So equal protection of law and all that.
I'm wondering, are there cases more recent than what you're bringing up that would support you?
Well, I believe the June 2002.
I mean, that's 20 years ago. So there's been 20 years.
Well, they don't roll on every... And I don't know how many cases that you have before the Supreme Court of First Amendment when Congress makes no fucking law to do it, that they have cases where they chose to make laws.
Well,
so somebody swore their oath to abide by the Constitution, so why would you have any cases if you're not supposed to make any laws? Or bridge them? There shouldn't be any. If everybody's following it, there shouldn't be any case law of this crazy insanity.
Here we are.
Oh, and then, so I don't want to prolong, and I'm just going to get worked up, so I just need to So here, again, can we file verbal petitions, and can public notice give notice to the government?
In this day and age, I don't see why not.
Right. So there. And then here, let's examine Trop versus Dawes. And here it said, there may be no involved physical mistreatment, no primitive torture, There is instead a total destruction of individual status in organized society. It is a form of punishment more primitive than torture, for it destroys the individual's political existence that was centuries in development.
Wow, that's deep.
It subjects an individual to a fate of ever-increasing fear and distress. He knows not what discriminations may be established against him. And further, there was we are oath-bound to defend the Constitution. So here, let's examine Trop case. So he was punished for desertion where they took his citizen status.
Okay.
So the guy
he
appears...
is not even a citizen.
Well, they stripped him of citizens.
Okay.
But the individual was punished for a crime. Okay? Mm-hmm. And in Trop's case, he enjoyed rights of an illegal alien. So he had rights.
He had more rights than you do.
Right. And,
he had access
and then
to courts.
he mentions the discrimination that may be established against him. Okay? My particular, I'm being sanctioned for petitioning the government pursuant to my First Amendment. So I am being punished for exercising a federally protected right.
Yeah, this is messed up on
Hold on.
many levels.
Permanently adjourned from filing documents. So, in essence, there are no other rights if you cannot defend them. So I don't have any rights.
Right.
So I'm so far worse than Trop.
Right.
Right?
Yes.
And then, let's remember, so I had past cases going on, which were egregious, present cases, and I have future cases, or whatever. Because in the dismissal of the Gangale versus the Ohio, he does not have constitutions at this time. So that implies that he might have seen that they weren't ripe for the court, because...
At the time.
Right. So even in his filings, it implied that there could be a future. Right.
Wow.
So, and in that, he made this is the same judge made findings facts of OMVI, operating motor vehicle. So he knew it was defective. So then you start wondering, well, how did it get past initial appearance? You start asking the speedy trial issues or filing, if rules of criminal procedure are followed, and all this stuff. Like,
that was your
it
right.
appears that the judge knew before he put this order down that there were issues, and he didn't enumerate or discuss all these relevant factors.
No. How easy would it be not to
So
point out
now
any of this
let's go
stuff
back to Trop.
for him?
Trop. So Trop is a way he's asserting discriminations that may be established against him. I had discriminations
Already.
occurring. So if the United States government calls it more primitive than torture in Trop, do I have the torture charge against the United States judiciary?
Yes.
So that's a further federal question of whether there's torture here. Is the order, was it unconstitutional? So here's whether the order abridged the First Amendment. Was the order within strict accordance with established protection? Was it narrowly tailored of particular circumstances? Was there a right to be heard before the order was entered?
No.
Did the judge enumerate or discuss all relevant factors?
No.
Whether the Northern District Court violated rights in the past?
Yes.
Whether the suits involved genuine grievances? Was there adequate representation provided when the interest of justice requires? Did it deprive appellate review? Was the order in strict... did the order create impediments to justice?
Yes.
Was there procedural morasses or blocked access obstructing justice? Is it an intolerable restraint? Is it excessive? Is it cruel and unusual punishment?
Yes.
Was there proportionality to it? Did the judge abuse his discretion, abuse his power, or abuse his authority?
Yes.
Does the order deprive right of adequate, effective, and meaningful access to the courts? And then further, what does punished accordingly mean? So when I was sanctioned, it's asserting that I could be punished accordingly.
But for what? You haven't done anything.
So if the
to be
First Amendment
punished
can make no laws establishing or abridging, so what the hell is punished accordingly? So let's even assume says, you know what, I'm willing to risk contempt and be punished. So if I file, what is the punishment imposed on me?
Oh,
So aren't you supposed to know the punishment of crimes or offenses before an offense?
Before
So
you
is
do
this
it?
almost like retroactively sanctioning someone?
Yeah, I guess.
So I don't know the risk of should I take that chance, or am I dealing, remember, but I'm dealing with a court that blew out union,
Who's already against
right?
you.
Like I know
So we
things
can't
from this
really
court
take
and
that chance.
this venue that is engaged in such egregious behavior.
I'm not sure I'd take that
Is he-
chance.
And he already went up against the First Amendment.
Like-
Such sacred things. Do you chance it?
Yeah, who knows? They could do anything to you for no reason.
So here, does it destroy the Republican form of government in the continuity government? Justice Sandra J. O'Connor's case, like this. Does the order create an unconstitutional restraint? So if there's an unconstitutional, is it an irreparable injury? Am I entitled to immediate relief?
Yes.
Whether the court order created a freezing effect on the First Amendment. Does it create a freezing effect on due process and habeas corpus rights and
Yes,
civil rights?
yes.
There are no other rights if you cannot defend them. I believe the court was biased. I believe this was done maliciously. I believe it violates the First Amendment. And I believe I should be entitled to immediate relief. I hope that the public will examine this, understand just the magnitude of what was going on. Please notify your congressmen, your representatives, and whoever to inform them of this injustice. I'd like to thank you for your time. Thank you. Bye.